alcoholic liquors for human consumption.
Is it same as intoxicating liquor?
That's the question which lots of people have to deal with.
Right.
Because why would framers use different words in two different entries? But in this case, is primarily concerning states' jurisdiction over industrial alcohol or rectified spirit, for short, IA, industrial alcohol. And this rectified spirit is also called ethyl alcohol as an alternative. In synthetic second case, it was, that is 1990 Supreme Court, it was categorically held that rectified, the denatured spirit is industrial alcohol and is outside state's jurisdiction under Entry 8, List 2 of the 7th Schedule to the Constitution. Entry 8, List 2, when it refers to intoxicating liquor, deals only with potable alcohol when it is had as it is. Synthetic 2 further went to the extent of denying jurisdiction to states in relation to industrial alcohol, even under Entry 33, List 3, as product of a notified scheduled industry under the Industrial Development Regulation Act, hereinafter referred to as IDR, namely declaration by Parliament under Section 2 of the IDR Act, read with Section 18 of the IDR Act, covers the entire field, ousting states' jurisdiction. The sole issue broadly is whether states have legislative jurisdiction to deal with and regulate industrial alcohol, as well as the expanse of it, whether the jurisdiction is exclusive or concurrent. Synthetics 2 is erroneous on both the counts. It is for this reason that the reference order of the Constitution Bench dated 8/12/2010 doubts the correctness of it after meticulously examining the judgment. The state's jurisdiction over industrial alcohol can be exercised in two ways. A, state has jurisdiction and control over industrial alcohol under Entry 8, List 2. Or states have jurisdiction in respect of industrial alcohol under Entry 33, List 3 as product of notified scheduled industry under IDR Act. And the field is unoccupied. This is a statement which lots say mark, not that the field is unoccupied. Because Entry 33, List 3, question of occupied field will arise. Alcohol, commonly called rectified spirit of more than 95% V by V, including denatured spirit. This has two aspects. A, one, whether industrial alcohol is included in Entry 8, List 2 and is therefore within its exclusive jurisdiction and control, or two, whether it falls under Entry 24 of List 2 and therefore can travel on to Entry 52 of List 1 on specification of fermentation industry as a notified industry under Industrial Dispute Development and Regulation Act. But this question, if I may not pause for a moment and elaborate a little more. Entry 52 List 1 is the entry under which IDR Act was issued in the year 1951, enabling the center or the union to specify which of the industries it wants to take over. Now, Entry 52 is intricately linked with Entry 24 List 2. Lordship would have Entry 24.
We'd like to just sort of show us the entries so that we can
I'll come
the
to
outset.
I'll come to just
Let's
for
look at the entries first, so that the whole thing turns in on the construction of the entries in this case.
Quite right.
So let's look at the different entries which are involved. That's the best way to go about it. Then we'll of course read your question.
This is where the synthetics too had placed industrial alcohol, because IDR Act comes in. And fermentation industry was notified in the year 1956 under the schedule to the IDR Act, implying thereby that the declaration under IDR Act would apply, and this industry is abstracted from Entry 24 List 2 and goes on to Entry 52 List 1. So once a declaration is made, Entry 52 comes in operation. Otherwise, Entry 52 List 1 has it's a shell. It is inoperative unless there is a declaration. See, if I may place Entry 52. But what I'm saying is let us for a moment, for the purposes of analysis, take out the IDR Act or the declaration. Then what conclusion that comes to the fore is that Entry 24 is the basic entry where state has jurisdiction over industry. Now that word industry transports to or gets transported to Entry 52 on a declaration by Parliament. If Parliament makes a declaration.
No, that actually Entry 52, Entry 24 of List 1 of List 2 is made subject to Entry 52 of List 1. Entry 52 of List 1, which gives the dominance to a parliamentary law, is provided Parliament has made a declaration in a law.
Provided. That's what I'm saying. Not unless there is a declaration, the jurisdiction vests in the state.
Obviously, if
that's the point.
But Right, but once the declaration is made under entry 52
Then that part
law,
which is taken over goes to the union.
one further very interesting thing is, look at entry 54 in contrast to 52. I mean, we were dealing with entry 54 just 2 weeks ago.
Yes, yes, my.
Regulation of mines and mineral development. To the extent to which regulation and development under the control of the union is declared by parliament by law to be expedient in the public interest. Now, the words to the extent to which are interestingly absent in entry 52.
There is a reason.
So once parliament makes a declaration, in this, as in this case under section 2, the entirety of that field of that industry is within the control. It's not to the extent to which.
I'll answer that question. Note that question has very frequently arisen and lots of have answered it in a number of occasions. Note the word 54 here, if you Lordship would once again have a look at 54, there's a difference in the two entries. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by parliament by law to be expedient in public interest. Now, the word to the extent to which has been used for an obvious reason. Word not here, the entry 54 includes both the manufactory, that is mines. That's the factory part, the manufacturing part, and includes mineral. So there's nothing else there left. So both the things come over here on a declaration. Unlike industries, when a declaration is made, the product of the industry doesn't go there. Here, the product of the industry is taken over under entry 24. But in case of industry, entry 52, your Lordship may have entry 33, list 3. Supply and distribution don't go to entry 50.
So it's very interesting because once a declaration is made by law of parliament under entry 52, the trade and commerce is taken out of the field of entry 52 and immediately goes into entry 33 of list 3.
As product of the notified industry.
Right. So to the extent, therefore, regulation of trade and commerce, production, supply and distribution, goes into the concurrent list.
Concurrent list.
The law made then by the state legislature can be overridden by a law which is made by that's Article 254.
There's no difficulty, and I'll say, as I said,
but entry 33 is an indication that notwithstanding a declaration which is made under entry 52, a law made by parliament under entry 52 of list 1, subjects still lie in the province of the states, albeit under the concurrent list.
Yes.
Namely trade, commerce and
now,
supply and distribution.
Now, importantly, since Lordships have noticed this, kindly come to the state list again.
So in other words, the domain of entry 52 will be everything pertaining to that industry minus entry 33.
Yes.
Understand. And it will be more apparent if you Lordship.
Carving out an exception.
Yeah, absolutely.
Now,
Entry 33, list 3, it carves out an exception within the domain of entry 52, list 1.
yes, Lordship is right, Lord, because then now trade and commerce, supply and distribution would not come under entry 52, list 1. Even if it is a notified industry. Lower rates on similar goods manufactured or produced elsewhere in India. So duties of excise on the following goods. A, alcoholic liquors for human consumption.
Is it same as intoxicating liquor?
That's the question which Lordship will have to deal with.
Right.
Because why would framers use different words in two different entries? And the reason my answer is the legislative history is there. That is why.
Is there any liquor which is not intoxicating?
I don't think so. At least I have not experienced.
From the consumer, I suppose.
Just come from Holi, so you have
It depends on the person who drinks it, whether it is
And how
intoxicating or
how
not.
late?
That could be strength of the effect, but effect will be there.
Consumer.
Alcoholic liquors, they all
Yeah,
liquids
yeah.
containing alcohol, they are intoxicating. I can't imagine of a liquor which is not intoxicating. Be it industrial alcohol, of course, intoxicating means alcoholic content. Industrial alcohol has higher alcoholic content, that's all. It can't be had as it is, but then do we have whiskey as it is? No, we have it with soda or water normally.
That again,
That again depends. One is to say, which is the pro-state, we say the pro-federal principle, that if the entry is not made subject to a central entry, then the state entry must have its full operation. The other is to apply, though the constitution is federal, the constitution is federal with a certain weight in favor of the center, and then say that whether two entries overlap, then Article 246(1) will prevail. Because they cover exactly the overlapping field. There are two opposing viewpoints. Question is which one to adopt. And
Fair enough.
what does